everyone, I'm back. This is Angela, and you're listening to the Study for the Bar in Your Car podcast. So, I just wanted to go into a little bit of more information regarding the whole Palau thing. So, I go to Puerto Rico for the Thousand Lawyer Project Puerto Rican bar exam retreat. Sorry, the bar exam retreat is not for the Puerto Rican bar exam. It's in Puerto Rico, and it's for people taking the bar in all places, but not Puerto Rico. So it's fun, relax, study for the bar. So basically, you can feel like you're studying and that you haven't abandoned your bar studies. Well, the plane lands super late. We flew out of Philadelphia and we went directly to San Juan, Puerto Rico. The plane lands about like 2 in the morning when it was like 2 hours late, almost 3 hours late, because I don't know, there was a sticker that was needed that was on the other side of Philadelphia airport. Like I literally could have driven around the airport like 6 times in the time they had to bring the sticker to the plane. Anyhow, I digress. So I get off the plane and I'm waiting for my Uber to take me to the retreat or the house where the retreat is. And then I check my text messages and I see that, or I check my email on my phone and I see that I have an email from Palau. And it's a really short email that basically says, "Hey Angela, we're really sorry, but your waiver for the bar exam has been rejected. Thanks so much and best of luck in your future." And it was super short. And I'm like, what? Wait, I've already been given a waiver. In fact, I was given a waiver in 2023, and then I was given another one in 2025. And I was just like, why has my waiver been rejected when I already had a waiver? I was waiting for a decision on the bar exam, not the waiver. And so I wrote back and I'm like, the can you poll the people on the committee? And I heard back from a judge and he was just like, "No, it's strictly confidential." And I'm like, "Okay, but I had a waiver." And then he wrote back, "Well, the waiver from 2023 doesn't count." And I'm like, "Why is he talking about the waiver from 2023? I'm talking about the waiver from 2025. I'm sitting here waiting for confirmation to take the July 2025 bar exam, and I want to know if my July 2025 waiver, I already know that it's been approved, but I wasn't waiting for it to be approved. I was waiting for confirmation that I could take the exam, not for approval from the waiver, because I already had the waiver." And Palau basically like totally shut down. They're like, "It's confidential, you can't appeal, and it is what it is." And they can't even tell you like how to cure it. And so like through my whole vacation, I went back and forth with this judge, and in each email he wrote, "This is final. This is the last I'm saying about it." And then I would like respond back. So I was like the really annoying law student that's like, "Yeah, but what about, but what about?" And finally we worked it out, like what had happened. They had some wrong information and I had some wrong information. Things got crossed. But whatever, at the end of the day, I still can't take their bar exam. So I'm so over Palau. I thought they were a good place to take the bar, and maybe they are for some other people, but I've just been through too much with that. I'm like, I'm just so soured to the experience. I'm soured to the fact that they've given me wrong information, and they can't even tell you like basic information when they get stuff wrong. Like the reason why due process is so important is because, well, one of the reasons is that if there's a mistake, if there's no due process, you can't say, "Hey, wait a minute, there is a genuine mistake here." And anyhow, I know due process is something that's come up a lot in the news, but it also comes up with the bar exam. So anyhow, my plan B is to take the Marshall Islands bar exam. Marshall Islands has been excellent. I have to study for the bar exam for a different way because they've got different requirements, but whatever. Okay. So now, so Statute of Frauds. I really don't like the Statute of Frauds. And I want to be someone who's positive about stuff and positive about everything. But the Statute of Frauds is frankly just pretty annoying because you have to remember all of it. And it's not totally hard to remember, but like when you're under pressure and taking the bar exam, it is sometimes hard to remember all these statute of frauds. So for those of you who don't know, the statute of frauds is a form of a statute requiring certain kinds of contracts to be memorialized in writing against the party to whom they are to be enforced, with sufficient content to evidence the contract. And I think there is an anagram, my legs. So there's marriage, oh God, I don't know, yearly, I can't remember what it is. But anyhow, Claude and Maud are going to go all throughout the Statute of Frauds, and it's going to cover some stuff we've already covered before, so I hope you don't mind. And then after this podcast, we have, let's see, we go on to third parties, then after that, bar exam tips, and then after that, we have the contract law wrap up, and then after that, we go into evidence. So we are motoring through the bar exam here. All right. So I am a law clerk. I've worked as a judicial law clerk. I've worked as a certified legal intern. I do legal work for lawyers. So basically, I'm a ghostwriter. I work with attorneys across the USA. I don't work with pro se litigants. I work directly with attorneys. So if you are an attorney or you know an attorney who needs some legal help, and in terms of legal help, I mean like help with the volume of work that you have, please contact me. My email address for work is hello@legalwriterandlawclerk.com. If you'd like to contact me regarding the podcast, and no one has emailed me about the podcast yet, someone email me. Let me know you're out there. You can email me at podcast@studyforthebarinyourcar.com. Anyhow, reminder, AI isn't always correct, but I really try to correct this as best as I can. And normally when I have to correct it, I just redo the whole podcast rather than like cutting out bits of it because it's just so much easier. So you're listening to a podcast within a podcast, and now you're ready for our AI friends, who I dig them because they have a sense of humor like that's pretty wicked, and like you'll hear in the podcast coming up like how sort of funny they get, and it's hard sometimes for me to remember that like they aren't real, like they don't exist. Like if it weren't for my notes, you wouldn't like hear them talking. But somehow through the magic of AI, they seem very real. Anyhow, without further ado, here are our AI hosts, Claude and Maud.
Welcome to the deep dive, especially for those of you maybe studying for the bar in the car. Today is all about a big one in contract law, the Statute of Frauds. And we really have to thank Angela for sharing her law school notes with us. Her outlines on contracts are proving super helpful. We'll be leaning on those quite a bit today.
Absolutely. And the Statute of Frauds, well, it basically just says certain kinds of contracts need to be in writing to, hold up in court.
Right, to be enforceable.
Exactly. It can seem a bit tricky, but Angela's notes really lay it out clearly.
Yeah, that's our mission today, really.
Yeah.
We want to walk through the 6 main types of contracts that fall under the statute using Angela's notes as our roadmap. We're aiming for clarity, maybe giving you a few of those aha moments for your study sessions.
Pulling out the key nuggets, basically.
Precisely. Extracting those important bits from Angela's materials to make it all stick. Okay, let's jump in.
All right. So the first category, according to Angela's notes, is the sale of an interest in land.
Okay, land contracts.
Yeah, and it's not just selling the whole piece of property, right? It's any interest in land, though Angela does note exceptions for things like short-term leases or easements.
Got it. And her notes mention something interesting about oral deals for land, specifically if the seller performs.
That's right. If the seller actually goes through with it, conveys the property based on an oral agreement, then, well, the buyer's oral promise to pay is enforceable. The seller's full performance kind of takes it out of the statute.
Okay, so performance by the seller seals the deal, even if it was just spoken.
And then flipping that, Angela's outlines also talk about how a buyer might enforce an oral land deal. It's called part performance.
Ah, part performance. That rings a bell. But it varies, right?
It does vary by jurisdiction, yeah. But her notes say most places look for the buyer to have done at least 2 out of 3 things.
Okay, what are the 3?
So number 1, payment, like paying all or part of the price. 2, taking possession of the land. And 3, making valuable improvements. Think building something, major landscaping, that kind of thing.
Right. So you need a combo. payment and possession, or possession and improvements.
Exactly. And Angela's notes give a pretty good example. Imagine a rancher orally agrees to buy land from a farmer.
Okay.
If the rancher pays some money and then maybe puts up fences and starts grazing cattle, well, that's payment plus possession.
The fencing and grazing show possession.
That combination could make the oral agreement enforceable even without a written contract. Angela's notes really highlight that practical side.
That makes sense. So bottom line for land, based on her notes, most transfers need writing, unless you've got that full performance by the seller or that sufficient part performance by the buyer. Short leases and easements are kind of their own thing.
Nicely put. Okay, ready for number 2? This one's big for commercial stuff.
Let's do it.
Sale of goods for $500 or more. This falls under the UCC, the Uniform Commercial Code. Angela's materials make that link clear.
The UCC.
Right.
Standard rules for business deals across states. So what does Angela's outline say you need in the writing for these UCC contracts? A memo or something?
Yeah, a sufficient memorandum, as they call it. According to her notes, it needs basically 4 things. First, it has to show a contract was actually made.
Okay.
Second, got to identify the parties, buyer and seller. Third, and this is super important under the UCC, a quantity term. How much stuff are we talking about?
Quantity is key. Got it. And fourth?
It needs to be signed by the person you're trying to enforce it against, the party to be charged.
Signed. Now, Angela's notes had something about what counts as a signature here, didn't they? It wasn't just, pen on paper.
Exactly. Her materials point out the UCC is pretty liberal about signatures. It can be any mark or symbol intended to authenticate the document. Even a company letterhead can work.
Huh. Okay, so intent matters more than the specific form. Interesting. Now, are there ways around the writing requirement for goods over $500? Exceptions in Angela's notes.
Yes, a couple of the big ones mentioned in her outlines. One is if the buyer actually receives and accepts the goods, or if the seller receives and accepts payment.
So actions speak louder than words sometimes.
Kind of, yeah. If the goods are accepted or payment is accepted, the contract is enforceable, but only, and this is key, up to the amount of goods accepted or payment made. It shows there was a deal for at least that much.
Okay, that makes practical sense. What about that quantity term again? Angela's notes had a specific point there too, I think.
They did. Her notes stress that if you do have a written contract under the UCC Statute of Frauds, it's only enforceable up to the quantity stated in that writing.
So if the paper says 100 widgets, you can't later claim you orally agreed to 200.
Not based on that writing, no. Her example involved gears for a watch owner. If the writing says 2,000 gears, but they talk about another 1,000 later, the enforceable part is just the 2,000 from the writing.
Got it. Stick to the written quantity. And one more UCC exception from Angela's materials. Specially made goods.
Right, the specially manufactured goods exception. This is pretty specific. Her notes explain you don't need a writing if, 1, the goods are custom made for that buyer. 2, they aren't really sellable to anyone else in the ordinary course of business. 3, the seller has already substantially started making them or committed to getting them.
Before the buyer tries to back out.
Yes, before any notice of repudiation. And the circumstances have to clearly show the goods were for that buyer. It protects the seller who's invested in something unique.
Makes sense. You can't just leave the seller hanging with custom stuff nobody else wants. Okay, that covers UCC goods pretty well, thanks to Angela's notes. What's number 3?
Third category from the notes. Contracts made in consideration of marriage.
The marriage one. This always sounds a bit old-fashioned.
It can seem that way. But Angela's notes clarify it's not usually about the simple promise to marry someone. It's more about promises made because of the marriage or contingent on it, like prenuptial agreements dealing with property. If you promise to give someone property if they marry you, that often needs writing.
So it's the I'll give you X if we get married kind of promise, not just will you marry me?
Exactly. The marriage is the consideration for the other promise. Angela's notes don't dive into examples here, but that distinction is the key takeaway.
Okay, good clarification. Number 4 from Angela's outlines.
Contracts that cannot possibly be performed within 1 year from the date they are made.
The 1-year rule. This one trips people up.
It really does. And Angela's notes emphasize the crucial word, possibly. It's not about whether it will take longer than a year, or even if it's likely to.
It's about possibility.
Yes. Is there any conceivable way the contract could be fully completed within 1 year of making it? If the answer is yes, even if it's a long shot, then it does not need to be in writing under this rule, according to her notes.
Even if it actually ends up taking 5 years?
Even then, if completion within a year was theoretically possible at the outset, it's outside the statute.
Okay. Angela's Materials had an example here, right? Something about insurance.
Yeah, a good one. Imagine an oral contract for fire insurance on a house for, say, 6 years.
6 years. Sounds like it needs writing.
You'd think so. But, as Angela's notes explain, could the house burn down within the first year?
Oh, yeah, unfortunately.
Right. And if it did, the insurance company would have to pay out the claim, fully perform its side of the bargain within that first year. Because full performance is possible within a year, that 6-year oral insurance contract is actually enforceable. It falls outside the statute.
Wow. Okay, that any possibility rule is really powerful. A key point from Angela's notes for sure. All right, what's number 5?
Suretyship. This is basically promising to answer for the debt or default of another person.
Like guaranteeing someone's loan.
Exactly. You're the surety, the backup person. And Angela's notes state the general rule. A surety's promise needs to be in writing to be enforceable. Protects people from casually agreeing to cover huge debts.
Makes sense. But her notes also pointed out a tricky timing issue, especially with gratuitous sureties. People doing it for free?
Yes, very important point in her outlines. If someone promises to be a surety after the creditor has already given the loan or whatever benefit to the main debtor, there might be no consideration for the surety's promise.
Ah, the consideration problem. Because the creditor didn't give anything new in exchange for the surety's later promise.
Precisely. It relates to the pre-existing duty rule. The creditor was already owed the money or had already performed, so a later gratuitous promise by a surety might fail for lack of consideration, even if it is in writing. Angela's notes really flag this.
And there was that example in her notes about Beth, her dad, and the car loan.
Yeah, perfect illustration. Beth buys a car from Sam, pays some, gives a note for the rest. After the deal is done, title transferred, Sam asks Beth to get a guarantor.
Okay.
Beth's dad then sends Sam a letter promising to pay if Beth defaults.
So the promise is in writing.
It is. But according to the analysis in Angela's notes, the dad's promise probably isn't enforceable. Why? Because Sam had already sold the car and accepted the note before the dad made his promise. Sam didn't give any new consideration for the dad's guarantee.
Wow, so the timing is critical. If the surety's promise is part of the original deal, when the credit is first extended, then there is consideration, and the writing requirement applies. But a later promise needs new consideration. That's a huge takeaway from her notes.
Absolutely. Okay, last one. Number 6 from Angela's materials.
All right, the final category.
When an executor or administrator of an estate promises to pay the estate's debts using their own personal funds.
Okay, wait, this isn't just the executor paying bills from the estate's bank account, right?
No, exactly. Angela's notes are clear on this. It's only when the executor says, okay, the estate is short, I will personally pay this debt from my own money.
Putting their own assets on the line.
That's the key. That personal promise to cover estate debts needs to be in writing according to the statute. If they're just managing the estate's assets, no personal promise, then this rule doesn't apply. Her notes keep it focused on that personal liability aspect.
Got it. No specific examples in her notes here, but the concept is clear. Executors' personal funds need a written promise. Okay, whew. That's the 6.
That's the list according to Angela's outlines.
So just to quickly recap for everyone listening, maybe jotting this down based on Angela's excellent notes, we need writing for 1, sale of interest in land.
2, sale of goods $500 or more under the UCC.
3, contracts in consideration of marriage.
4, contracts impossible to perform within 1 year.
5, suretyship promises.
And 6, an executor promising to pay estate debts personally.
Great summary. And as you're studying, remember those key exceptions and nuances we talked about? Pulled from Angela's materials, part performance for land, the UCC exceptions for goods, that any possibility rule for the 1-year contracts, and the timing for surety consideration.
Definitely keep those handy. They are classic bar exam fodder.
Absolutely. And maybe here's something to mull over, kind of building on Angela's framework.
Yeah.
Why these 6 types? Is there some common theme? Maybe a higher risk of fraud, or the transactions are just seen as more significant. We're thinking about why the law singles these out for a writing requirement.
That's a great thought provoker. Why these specific agreements?
And again, huge thanks to Angela. Her law school notes have been invaluable for putting this deep dive together for you.
Yeah, this has been a solid run-through of a really core contract law topic. Hopefully breaking it down like this using Angela's structure helps you lock it in.
We hope so.
Yeah.
Think about how spotting these situations quickly will help on practice questions, and, the real deal. And definitely check if Angela's notes cover related stuff, like maybe the parole evidence rule, or dive deeper into UCC Article 2.
Good suggestions. Exploring those related areas would definitely build on this foundation. Well, our goal is always to make these tough subjects a bit more manageable, especially when you're studying on the move.
It's exactly. Keep up the great work, everyone, until our next deep dive.
Hey, this is Angela. I'm back, and I really hope you enjoyed the Statute of Frauds. So, remember my legs. I probably should have Googled what that stands for. I forget, but that is the anagram for you to remember the Statute of Frauds. So, M, marriage, I think, Y, year, I think the L is long. I'm not sure. Anyhow. So a few reminders. I'm a student just like you, and I don't remember everything, and I am not an expert. I haven't passed a state bar yet, but I am barred with 2 Native American travel courts, federally recognized. Anyhow, so I'm not giving you legal advice, and AI is not a substitute for studying the law yourself. So I recommend that you still hit the books, but use this podcast just sort of as filler stuff. So when you're in your car, when you're in the shower, when you're really trying to maximize your bar study for those down moments when you're like, wow, I have some time here, I really could be studying or listening to something, use this podcast. And it's really important that when you're driving, when you're on the road, be safe. So if evidence is going to distract you from driving, perhaps hit pause or listen at a later time. Now, if you'd like to contact me about the podcast, you can email me at podcast@studyforthebarinyourcar.com. Remember, I'm a legal writer, I'm a law clerk, and I do freelance work for attorneys around the world. So if you are an attorney or you know an attorney who needs a law clerk, ad hoc law clerk, and remote, have them email me at hello@legalwriterandlawclerk.com. That's it for now, and we'll see you on the next episode. Bye.